Hi, this is Mario from ESCO, and just want to go over a couple of things that all Amazon sellers should know about intellectual property. We get a lot of calls and messages, emails, kind of confusing the difference between patents, copyrights, and trademarks. So just want to go over those with you guys. So patents, copyrights, and trademarks all fall into intellectual property. So when someone says intellectual property or IP, they're referring to intellectual property again, which comprises of patents, copyrights, and trademarks. So let's go ahead and get started with patents first. So anytime you hear patents, the first thing that should come to mind are inventions. So patents, inventions. So two different kinds of patents. There's utility patents and there's design patents. So with utility patents, think about functionality anytime you hear that. So with design patents, it's protecting the ornamental aspects of the product. So both of them are patents, but one of them protects functionality. So that would mean, for example, anything that has any utility to it or functionality, such as, for example, it could be a new electric motor that was invented, or it could be, for example, the iPhone, AirPods, things like that. The inner working of it and the functionality of it are all protected by utility patents. Now, with design patents, think about it as protecting the ornamental aspects of it. So the way it looks, right? For example, Apple has, going back to Apple and their AirPods, they have a design patent on the AirPods and on the iPhone. So the way it looks, design patents don't care about the functionality, how it works, or any of that, but design patents do, right? Now, with patents, they can last from 14 to 20 years from the date of registration or filing. So what that means is design patents, they last 14 years and utility patents can last 20 years. This is assuming that all maintenance documents are filed with a USPTO. Okay, so how do you decipher between a utility patent and design patent? So anytime you see a patent number for design patents, it'll have a D in front for design, and usually it'll be something like this, 787. So it'll be the D in the front and then 6 digits afterwards. Where with utility patents, it's just the numbers. It won't have the D in front. Okay, so that's patents. Now, a lot of people kind of confuse it and say, "Can I patent my logo? Can I patent my brand name?" No, patent again is for invention. So think of that. Now with design patents, that protects the ornamental design of aspect of it. So we'll dive more into detail in just a few minutes. So next is going to be copyrights. So anytime you guys hear copyrights, I want you guys automatically to think about art or artwork. So things that are protected by copyrights are books, plays, music. What else? Any form of artwork, things like that. Now, how does that relate to Amazon PL sellers? Well, you guys could copyright your ebooks if you guys create those, or those photographs you guys get taken of your products. You guys can also protect those with a copyright. So, product photos. With ebooks, what the higher end sellers, what they do is when they create the ebook, they go ahead and get a copyright on that. Now, if there's a hijacker, then the hijacker most likely is selling the same product or a knockoff of it, but they're not sending the ebooks after each Amazon customer purchase it. So that's one way of kind of setting yourself apart or differentiating yourself from the competition or any hijackers, is having an ebook created and then getting that copywritten. And again, you guys could kind of go after the hijacker for copyright infringement if they are kind of stealing that book, your ebook idea, and also selling or sending that out to Amazon customers. A lot of people also sell ebooks that they create and publish on the Amazon Kindle network. So that's another idea, is whether you're selling ebooks or giving it away as a bonus with each one of your physical product orders, you guys could protect that with the copyright. And then product photos, obviously those you guys could go ahead and protect with the copyright. If someone else is doing the photos for you or creating the ebooks for you, make sure you guys get an agreement that says that they are working for you guys and it is work for hire. Okay, so make sure you guys get that from everyone that's creating ebooks or doing the photos from you guys. So next, let's talk about trademarks. So anytime you guys hear trademark, I want you guys to think about brands. Okay, so trademarks, essentially two different kind of components to it. One I'll just call regular trademark, but the other one is a trade dress. So trademark, regular trademark, there's two different kinds. It'll be a word mark or a design mark. So word mark, you're just protecting the plain spelling of your brand name. There's no stylized version of it. Font's not different. No colors, doesn't care. It's just looking at the words. For example, if you've got Acme as your brand name, then it just protects that name. So it doesn't care what color it is, what font it's in, so or anything else. With design mark, this is the logo. So think of that as the logo. So with this, it does protect or can protect the color, the font it's using, any stylized versions of the design, or just any kind of pictures or kind of drawing element you guys have to it. So those are the two different kinds, right? But also trademarks, you guys could also trademark like a color, a scent, or anything like that. So just keep that in mind. But the main purpose of a trademark is to kind of differentiate yourself from the competition. So when someone, for example, hears the brand name Acme, they should be able to associate that with the brand and kind of where or the origin of the product, where it came from. For example, if you guys hear Microsoft and see that on a product, you guys automatically assume that the company is Microsoft and that's who created it, right? So if you guys see, for example, tires that have Microsoft on it, most likely most people will associate that with the computer manufacturer or the software manufacturer. So that's the main purpose of it, is to kind of designate the origin of each product. So that's the main purpose of trademarks. Now, going back to trade dress protects the way a product looks. For example, Jack Daniel's has a trade dress on their bottle, the way their bottle looks. So that's trade dress. Also, there's insulation. Let me just go to this. There's insulation. It's by Owens Corning, and it's a pink color. So no one else can make insulation that goes kind of between the walls of your home. No one else can make this a pink color. They've got a trademark on that, and that's how they differentiate their product from the competition. So if you guys go into Home Depot or Lowe's, you guys will see this, and I can guarantee you they're the only ones that have the pink ones, the pink insulation. Also, another example, a lot of women, I'm sure, are familiar with this, the Louboutins, the red bottoms. Trying to get a better image. But the bottoms of these, they're all red. They're shoes, and they've got a trade dress on that. So no one else can make shoes that have red bottoms. I wish they had a better picture. It doesn't look like they do. Anyways, you guys get the point. The bottom of it, it's all red. Okay, so they've got a trade dress on that. The beautiful thing about trademarks, they can last forever as long as you're using it. So in order for it to last forever, you've got to be using it in commerce and also file appropriate maintenance documentation with the USPTO. So that's why trademarks kind of can be better than doing a patent or having a patent or a copyright. That's one of the reasons, although they're each for different protections. But again, trademarks can last forever. Now, so if trade dress is for ornamental protection, and the way your product looks, and so is the design patent, then what's the difference between those, right? So design patent versus trade dress. So again, let's keep in mind one is a patent, the other one is a trademark, a form of trademark. So what is the difference? With patents, you guys or a patent holder can have a patent on a design patent, how a product looks, but never use it in commerce, and that would still be valid for up to 14 years, assuming all documentation has been filed. This is for a design patent, right? Now with trade dress, the way the product looks has to be used in commerce, and it can last forever. Must be used in commerce. This one, no use required. Okay. So that's really the main difference. One, keep in mind with trademarks, we always think about brand. So the trade dress, the way your product looks, for example, the pink insulation or the red bottom shoes, they have to be linked back to the brand. So it has to, when a consumer or customer sees that product, they should be able to associate it with a brand. For example, like we mentioned, when you see pink insulation, you think of Owens Corning, or at least that's what you should. With red bottom shoes, you automatically should be thinking about the Louboutins. So same thing with here. With trade dress, it should be linked back to the brand. Where with design patents, you could create a design patent as far as how a product should look. For example, if you've got an idea for a headphone or phone or a new computer, the way it should look, then you could go ahead and get that patent and never use it again. And you could have that protection for 14 years. Where with trade dress, you have to use it in commerce, okay? One more thing about patents. So the main purpose of a patent is to kind of give the developer or the inventor a monopoly. I just want to go back to that page for patents. That says monopoly. Okay, so patents, the purpose of it is to give the inventor or developer a monopoly over that product or invention or the way the product looks. Now, what's the reason behind that? Think about the pharmaceutical companies and how many millions they spend on research for new drugs. So whenever they get that, create that new drug, the government wants to give them a monopoly. So they're the only ones that can sell that drug for a fixed period of time. And again, the reasoning behind that is so they could recoup their investment, their research money that they've spent, and all of that. That's the idea of a patent. For example, Tylenol, they had a patent on that when it came out. But after 20 years, that is now available for the public. So anyone can go ahead and use that formula to create the same thing. Now, they can't call it Tylenol. They'll have to call it something else, but that's the reason that we have generic drugs, right? It's just essentially a knockoff of the patented version of that firstly developed drug. So the reason why people can't call it Tylenol is because that's their trademark name. That's their brand name of that drug. So again, keep in mind, trademarks can last forever as long as you're using it. But with a patent, so for example, the drug formula for Tylenol, that would only be valid for 20 years. Okay, so those are kind of the basics between patents, copyrights, and trademarks. And I think all Amazon sellers should kind of know about that. And just want to kind of go over strategy before I end this video. So if utility patents are good for 20 years, right? This is patents, utility patents. They're good for 20 years. With some advanced Amazon sellers, what they're doing to find new products is they're looking for patents that are about to expire. They're looking for patents that are about to expire, and then they go ahead and create that kind of, I don't want to say knockoff because it's not a knockoff, but they go ahead and create that same patented product because now their protection is over. So that's one way, and there are ways to search the USPTO for expiring patents. And if you guys want to see that video, we should have it coming up in the next week or so, where we'll go over how to find patents that are going to be expiring soon and just another way to kind of find new products for you to go into as an Amazon PL sellers. So if you guys are interested in that video, go ahead and like and subscribe, and we'll have that video coming up soon. If you guys have any further questions about any intellectual property we went over, whether it's patents, copyrights, or trademarks, feel free to send us an email at info@esco.com or call us. Let me just go to our website. So that's our website, esqgo.com, and our phone number is 424-363-6233. You guys could also contact us with this form over here, and we'll be more than glad to answer any questions you guys have. All right, any other questions, please go ahead and post it below the video, and we'll make sure to answer those. Thank you.